Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you and welcome to the Jury Thinks What, a podcast for trial lawyers. My name is Saul Gruber from Gruber Trial Consulting, and we're starting our second season and pretty excited with the feedback we've had from trial lawyers all over the country. Today, our guest is none other than Christian Morris, an absolute rock star trial lawyer out of Las Vegas, Nevada, from Nettles Morris. Christian is not only just brilliant, but she's fun to listen to. She really enjoys being a trial lawyer. And we first wanted her to be a guest because of her $31 million verdict earlier this year in a malpractice case. And Christian has been doing some speaking regarding that and really wanted to talk about something else. And I'm so thankful that she did. I think you're going to love what you hear from Christian. And she really breaks down what it means to be a trial lawyer and how everybody can be one if they're willing to be vulnerable and put the work in. So I think you're going to enjoy this. Here is the Nevada Justice Association's 2019 Trial Lawyer of the Year, Christian Morris. So today we are here opening up our second season for whatever that means. And we are here today with Christian Morris from Nettles Morris in Las Vegas. Good morning, Christian.
Good morning.
How are you doing today?
I'm doing great, getting ready for another trial. So my stress level is where it is usually, but I think I can handle it.
Well, that's good. So we have you at that perfect level where you're ready to do something, and we'll give you an outlet to do something in.
Perfect.
Christian is partners with Brian Nettles, who a lot of our listener knows, but you have been rocking and rolling in Las Vegas for a number of years now, from what I'm looking at in the verdict sheets. Some pretty impressive stuff.
So, someone has to pay Brian Nettles' mortgage, and I have taken that burden on.
Well, that's good because, and I think you're right. And I think anybody who knows Brian realizes somebody else has to pay his mortgage. But I mean, not just the recent verdict that you've got, I think within the last 6 months, the $31 million verdict, but I mean, case after case after case, tough case, difficult case, to the point where in 2019, Nevada Justice Association named you Trial Lawyer of the Year. Is that right?
Yeah, that is right. It was, in fact, I'm so glad that I got that recognition before you get a big old verdict, because it meant so much that they were valuing the quality of the work and not the amount of the verdict. I thought that was really important. And it's nice to have the big numbers, but I think really looking at the people who are on the ground trying those cases that need to be tried because they are difficult, because they are tough, is really important.
And that's kind of what this podcast was started for, is not necessarily just talk to the authors, as I like to say, although this season we're having a bunch of them, but it's to talk to the people that are on the ground, picking the juries, not only in that large medical malpractice case, but the left-hand turn case with the maybe herniated disc in the neck as well, and trying to figure out what people are really going to think and what they want to do. I know that always impressed me when I still practiced, was the lawyers that were there every Monday in the courthouse, ready to start some trial.
Yeah, and that's the funny thing is, like, you really know who tries the cases, because if I haven't seen you at the courthouse, you're not trying the cases.
No, ain't that the truth?
Yeah,
I hear you. And I watched, because I'm supposed to do some sort of research on guests. So at least that's what they tell me. I just try to get people who I know. But I watched the video that was put out for your 2019 Trial Lawyer of the Year. There are some impressive people talking about your skills, but they weren't just saying, oh, wow, you destroy experts. They were saying that you're always prepared, you're always ready to go, And if someone says you can't win or you can't do this, that just makes you want to do it even more.
Oh yeah, I mean, that's the beauty of it is, I mean, I've hopped on cases where it's, going to trial in 3 days and someone just really needs my help. And, that just means I don't sleep for 3 days because I'm not going to walk in there and kind of throw stuff at the fan and, see what happens. And so I really do pride myself on always being prepared. But even more importantly, I'm not aggressive anymore. I'm not argumentative. I use a lot of skills that I learned at the Jerry Spence. It's called the Spence method now, but
right.
At the Trial Lawyers College. And it really is like more soft, empathetic crosses. And, I'm not arguing and yelling at anyone. And it actually has been over the last so 2013 is when I went to the college. I came back and the way I tried cases changed. And
wow.
I became so much more relaxed and so much more organized because I wasn't in this fight or flight in my head all the time. And it really, I think, helps me be perceived not only by the judges in a more professional light, but the jury is so much more receptive to a even-keeled, calm female. And it really did help me kind of get better self-perception on how I looked at trial.
That's fascinating because I never went to the ranch, but I certainly took some of the regional things. And I've always found that empathy was very difficult for me. Maybe it was just my personality. And it never really, I had a lot of trouble with it. And I think it really hampered some of the verdicts that I've gotten in the past because, some of the lowest verdicts that we got when trying nursing home cases should have been the highest verdicts. But I think the way we aggressively went after some of the witnesses had a negative impact on how the jury perceived us. So that's some fascinating stuff. In fact, I talked to Betsy Green this morning, and Betsy and I just picked a date where she's going to talk to us about.
I love Betsy.
About some of the trial. We're going to talk solely about how she's used trial lawyer college methods to help her, become the number one trial lawyer apparently in Indiana. That's what they keep ranking her. So let's take us back a little bit. How did you know you wanted to be a trial lawyer?
So, there's a couple of things, and it's funny because when you look back on it, I think what you were thinking at the time is subjective, right? Because you're like, oh, I think that's when it was. But, I do remember when I was younger, my parents got sued, and it was a week-long jury trial. And the man defending my family just was terrible. I mean, I remember just sitting there like, wow, this is really bad. And it was a plaintiff's verdict. So the verdict was, against my parents. And I was like, gosh, I really did think I could do a lot better than he did. But, as I went through life, I just wanted to be successful. And I wasn't really book smart enough. I wasn't going to make it into medical school. I was always working like 3 jobs and going to college, like commuting to school. I just wasn't one of those like studious individuals. But I was smart enough to be able to get a high enough score to get into a couple of law schools. And so when I was in law school, I thought I wanted to do contracts. But then I started interning at the district attorney's office and the public defender's office. And I loved the personalities there. They weren't so, judgmental and detail oriented. It was kind of like, let's get in there, let's stand up, let's get going. And I loved that because they were less lawyerly than all of the other people who were like, oh, there should be a comma here and a period there. And so for my personality type, I thought, I think I really need to be in the courtroom because I'm more of a big picture person.
Right.
So that's kind of where I thought, all right, so I got to find a way to be more using my body and my mind than sitting at a desk and typing and reading.
Oh, yes. We always had appellate counsel for our cases because A, I was a horrible writer, still am. And B, I didn't have the patience to sit till 1 a.m. typing on my computer, unless it's like a direct or something like that.
That's the thing. I can work on a cross for like 15 hours nonstop, but I certainly can't write. I don't even know what a complete sentence is. Let's be honest.
I hear you. And there's something a little bit more exciting once you start getting involved in trials. I keep telling people when they say, well, my daughter is a great arguer, I told her she should be a trial lawyer. I'm like, well, I think there may be a little bit more than just being able to argue, right?
I hear that all the time. People are like, I like to debate. And I'm like, okay, I didn't. So you know what I mean? Like, I'm not really sure how to connect it.
You know, and I don't think people, and I definitely want to talk to you about a couple of things. I'm not ignoring your big verdict, but I want to get into your mindset a little bit about trying cases, because that's really what I think is fascinating. You know, everybody always says, oh, that cross was great. And they have no idea the preparation it takes for a 10-minute cross-examination.
Yeah, it's amazing. I mean, there's something about trial work that, and I always tell my husband, there is no greater high.
Mm-hmm.
There's also no worse low.
Well, that's the truth.
I mean, I will be on cloud nine, regardless of the size of the verdict, when I get a plaintiff's verdict. And when I lose, man, I am a bawling mess. Like, I got no shame in my game. I am crying on the phone to everybody I know because I have failed. And not only have I failed myself, I've failed someone else. And I take the responsibility. I don't blame anyone. I don't say, oh, it's because of the judge or because of that. I internalize it as my fault.
So I just spoke to KJA, the Kentucky Justice Association convention, which luckily they had in Nashville, which made for a whole different week. But and my speech was about wellness. And what I reminded all the lawyers was, you have to remember, when we lose, we don't just lose, but the family that trusted us for 3 years, that we lived with, that we died with, right, that we prepped every step of the way, you feel a little piece of you went with them. And there's only so many little pieces we have to be giving out.
Yeah.
And I think that's really important for trial lawyers to remember. I mean, if it doesn't have a deep impact on you, a loss, then you're probably doing something wrong, not right.
Oh, yeah. So on this recent verdict, it was a big verdict. And I was asking for big numbers. So I thought they'd be out a while deliberating. Well, they only deliberated a couple of hours.
Oh, boy.
And I was like, oh my, it's like a pregnancy. Like, it's premature. The baby can't come out yet. And so I get down to the convention center, because that's where we tried the case. And my client's dad, because she can't speak, she's a quadriplegic, so she couldn't even be at the trial, was like, Christian, you know, it doesn't matter what the verdict is. And I'm like, no, Jack, it does. My job is to get the ball across the finish line. That's my sole job in life. And so we're sitting there, and he came up and sat beside me while they were about to read the verdict, and he put his hand on me, and he's like, are you shaking? And like, my entire body was shaking.
I believe it. I definitely,
because that's just how much I was invested. And if I had let them down, my husband was like, thank God you won. Like, I wouldn't want to deal with you if you lost.
But it's really true, though. I mean, I don't think people who don't try cases realize that how much of us goes into that. And sadly, in New Jersey, where I practiced for over 30 years, there was always so much else going on. So a judge would never give you 5 straight days of trial days. So our trials would go on, especially malpractice cases, which I did for 3 weeks, 3.5 weeks. So now that's, 4 weekends of not sleeping. And I mean, I literally would lose 10 pounds every trial.
Oh yeah, I lost weight. It was great.
Yeah, I'd say, and luckily I put 20 back on after the trial, so it was okay. But there is a lot that goes into what we do, and that's kind of what I really want to talk to you about, because you're one of the people that have boots on the ground, and you're out there, even if it's a $5,000 case. I mean, you're out there still fighting, just to fight the fight.
Oh, 100%. The case I have going next week. I mean, it's a torn meniscus and it's a torn rotator cuff. It's not huge. Mm-hmm. But that doesn't mean I'm not going to give it my all, because he deserves the same amount of justice that the big verdicts get. So, I'm always like, no matter what it is, they know I'll waste my time.
So I'm looking at this. Let's forget about the $31 million verdict for now. We're going to talk about that. We're going to bring that in. But, as trial lawyers, how do you get yourself up after getting a $30 million verdict to handle the torn meniscus case?
Well, I mean, I think that the issue is for me, is I know I'm going to feel just as bad if I don't do just as well. And it really is, and I've always said it, because some of my most prized verdicts that have changed the law in Nevada. And there are two of them. One changed the law on open and obvious, whether there's a comparative negligence issue on a slip and fall case or a trip and fall case. And the other one allows plaintiffs' counsels to get their contract rate for attorney's fees. They don't have to make up all this billing that they never did.
Oh, really?
And those cases came, one of them, they offered me $2,500. And I took it to trial and got $100,000, and that changed the law on open and obvious. And the other one, they offered me $5,000, and I took it to trial and got $400,000, and that was the verdict on the attorney's fees.
That's unbelievable.
Yeah, and I mean, no, like everyone's like, oh yeah. I mean, the one with 400,000, she had like 38 grand in meds. I just didn't board the meds, and so the jury just assumed there were a lot more, or assumed that she was, had all the, because she had significant injuries, but just hadn't treated a lot for them. But those are the ones where they're like, oh, she's just going to take it. All these other attorneys have dropped the cases. And it literally makes an impact for every single plaintiff and plaintiff's counsel in the state. And that's awesome.
So let's talk about that for a minute, because we all see those cases, right? That either the plaintiff may be a little too active with an opinion in their case, or maybe it's a missed case, no damage. And we're just, I really don't want to do this. How do you get yourself to the point where you say, not only do I want to do this, but I'm going to get a $400,000 verdict doing it?
So the way I do it is I never say out loud, I don't want to do this. I tell everyone I'm dying to do it. And the reason why is I need them to be motivated so the energy is right. Never do I dread taking a deposition. Never do I dread meeting with a client. I can't let myself do it, or I am going to forget the mission that I'm on. And so, of course, do I get tired? Does it get to be, wearing on you? Absolutely. But if I let that creep in and take over and change my mantra, I don't think I would be the trial lawyer that I am today. So I get excited about it. When someone brings me a case note, it's really difficult. I'm like, that's awesome. Let's get creative. Because if you do that, then it really shines through. And then the people around you, and I think that's an important thing, is to be what you want to be, you have to show by example. And if I had different thoughts in the back of my head, I would not be able to tell people, look, this is the coolest profession in the world. If you care, you can change someone's life, period. And that is just a fact. I mean, I had a case that nobody wanted. My client was on a crotch rocket going down Las Vegas Boulevard, playing 0 to 100 between the stoplights with a group of bikers. He didn't have a motorcycle license. Into a truck he goes and dies. And his mom couldn't get anyone to take that case.
I'm sure.
Yeah, but I did. And I dug so deeply into that trucking case, that trucking company, and how dirty they were. Millions was the settlement. And she sat there in the mediation and said, the only reason this is happening is because of you, Christian. And I had taken like 40 depositions. I had found the office manager where they forged employment documents in Arizona and got her to testify about the truth. And I mean, there was so much dirt in that trucking company that they had to resolve a case where liability seemed to be horrendous for the plaintiff. But
so actually,
I cared.
And plus you use the old, I don't know why people forget about this, the old mantra, it's about the defendant.
Oh, 100%. Yeah. What was that truck doing on Las Vegas Boulevard?
Right.
That guy's doing what everyone does, drives down it. It was backing into a casino. So, and it shouldn't be doing that, blocking Las Vegas Boulevard, in my opinion.
Yeah, well, and in the insurance company's opinion too, given the settlement. But that's interesting, and that's a tip that I think a lot of lawyers forget. I hear, I'm around trial lawyers, right? So are you. Sadly, 7 days a week, 24 hours. Right? I mean, my idea of taking my girlfriends on a vacation was we went to the KJA convention in Nashville, but we had days in Nashville, but we still were with everybody in from Kentucky. Right. And a lot of times I start hearing from a lot of the younger people who maybe don't get the opportunity to watch you at the Trial Lawyers University or listen to this podcast. They're worried about, well, what did the plaintiff do? When did the plaintiff do it? And what exactly were the plaintiff's injuries? As opposed to, why did the defendant do what they did, which put the plaintiff in harm, type of thing. And it's crazy when you hear people talk like that.
Well, I think what you just said is important. They're worried. And I think that's the issue, is that I don't understand why people are so worried. Trial is a crapshoot. So what's the point of worrying? You just say, hey, look, I need to reframe my issues. And so there's so many young attorneys who, and they say, oh, Christian, I want to watch you and be like you. Don't be like me, be like you. Right. And get in there and do it. And I think the issue is people are fearful of getting in there and just doing it. And you've got to, and this is why it's so important to try those small cases, because you should be practicing on those. When I first started trying cases, I had never seen a trial, not one.
Oh, really?
Yep. I've seen a criminal trial, but that was like when I was at the DA's office years before. I had never seen a trial. My friend was like, I have this trial. Can you help? I'm like, sure. Cause I I'll do anything. And I go in there and it's a bench trial, right? With one of the most conservative judges. And I sit down in the chair and the defense counsel looks at me and was like, are you first chair? And I'm like, well, I'm kind of like a half chair. Of course, my client was using substances and it was pretty obvious. And so I got a defense verdict and that was just the way it was going to go, but it's only up from there, right? Sure. And so I just started trying all these cases and I was winning some, and the ones I was losing, they probably should have been lost. You know what I mean?
That's exactly right.
Too hard. But as long as my client wanted to go, I would go. And I would tell them, can't guarantee anything, gonna try as hard as I can. But how in the world do you get experience unless you give yourself experience? Watching people isn't the same.
And isn't that part of the, I have this theory, and I'm not sure it's right, and it sounds like I'm just an old guy. But when I left law school in '88 and took the bar, you didn't just open your own firm, right? We would work at a firm. I would be writing briefs for a year, maybe 6 months. Then boom, I do a bench trial, maybe a workers' compensation trial. And then I'd be able to graduate to the, rear end hit trial, or really it was more of a left-hand turn case trial before I got to the rear end hits. But, everything was staged. There were lawyers who can go back and ask things too. Now I see people are opening and listen, I'm not criticizing them, but they're going right away, opening their own firm, and they skip that learning part and they've gone right to opening their own firm.
Yeah.
I think that's part of the problem. They're looking at the money aspect of it as opposed to the trial aspect of it.
Yeah. And I think that's, I think it's a problem in our profession is that clients are sometimes and many times considered cash cows. How much can we get for that? Not what justice can I get for this person? And it's so funny because justice comes in so many different sizes. And most of the time, the justice I can give people on smaller cases is that I stood up for them and they feel that and they feel valued and they feel respected. And I know that I can give that to them, even if I'm not giving them a lot of money. Right. And so that's something that, people really respect lawyers. I think, unfortunately, they don't really respect plaintiff lawyers due to the advertising and the way social conditioning. Right. But they do me because they know I'm taking time from my family, from my life, and I am respecting them. And if anyone, and that's the thing, when I hear people talk bad about their clients, that is unacceptable to me because everyone else is. And I won't be. I will give them all the respect that they are due. They came to me for help. I will help them as best I can and then move on. But when I hear people talk, oh, I got a crap client, don't say that because your client is coming to you for help and everyone else will be talking bad about them. So don't you. And I think if you kind of live in that world, it makes it a lot easier when you have difficult clients. I always call them complex. I'm like, well, that's a complex individual and we'll figure out a way to deal with them.
That's great. This is Saul Gruber with Christian Morris from Las Vegas on the Jury Thinks What, a podcast by trial lawyers for trial lawyers. Going to the point you just made, I still am in contact with the clients in which we tried the case and lost. Yeah. I mean, I've developed such great bonds over the years because exactly what you said. Not only did someone stand up and fight for them, but they were texting me at 11 o'clock at night. They know that I didn't sleep home for the week of their trial. I stayed in a hotel so I could be completely and utterly theirs. Yeah. And I mean, nobody's happy when you lose a trial, but they're always happy as long as you, the trial lawyer, put forth the right effort.
Oh, I'll never forget when I lost a medical malpractice case. And I was just standing in the hallway, and my client came up and hugged me and said, "Are you going to be okay?" Okay. She doesn't care.
So, all right. So, I mean, listen, we're active in AAJ. We're around people like each other all the time. How do we turn around and empower other lawyers to be that way?
I think that one, we need to stop acting like we are perfect and we're the ones who have it figured out. And I think that that's the reality is that a lot of attorneys are fearful that they'll never have it figured out. Well, neither do we, because you have to cherish the wins because you're going to have to survive the losses. And you have to be able to communicate with people that if you want to be a trial lawyer, all you have to do is try. That's it. If you're in there trying really hard and asking for help when you need it, not standing back and watching and taking notes, actually physically doing it and being okay with being imperfect, then you will be able to be an amazing trial lawyer. And that's the thing is, I think the message is that, hey, did you hear about my verdict? Send me more cases, right? No, I mean, the message should be, look how cool it is. At 40 years old, after trying cases for 14 years, I actually was allowed to try a phenomenal case, but I've been trying really bad cases for a very long time to get there. And so I think the message is that if you talk about the process more of how did you get here and not talk about this is how I am now, that's not helpful for anyone who isn't here now because it's the end result. Talking about how you get there, being scared, standing up in trial with your legs shaking, wondering, should I be objecting? Is that objectionable? I don't know what an offer of proof is. You know, all of these things that you learn by doing it. Then you're like, oh, that's how you get here. Not by like, oh, look at Christian. She's just been perfect since the day she popped out.
Yeah.
You know, it's not helpful for anyone.
Perfect. Perfection. I don't even understand that word because if you've ever listened, because the big thing in many jurisdictions is they audio tape trials.
Yeah.
Until you've listened to what you thought was the perfect opening, you don't know what you're doing because then you sit down and you say, oh my God, I sound like that? I can't. There's no way I sound like that.
Yeah.
I stopped striving for perfection actually well before I got out of high school, let alone going to law school. But I think you're right. Too many times people are taking books. And now I, like you, read the books every week, right? I just ordered Keith Mitnick's new book. You know?
Oh, yeah. So before every trial, I read a book.
Right.
It's like my motivation thing. Mm-hmm. And I speed read. I'm like, skim through. Ooh, that looks like it might be helpful. You know what I mean? Because I don't have that much time. But that's my motivation.
I actually, when I read them first, I highlight them. So whether it's, Keenan's book, Ball's book, or now the 10,000 books that are available on trial guides, I end up getting them. I'll read them on the beach, at the pool, highlight them. Then when I was still trying cases, before each trial, I'd pick which one I think is good and I'd read my highlights. Just to get me thinking the right way.
Exactly. Like rules of the road. Sometimes I just need it because I'm not that structured. And so I'm like, all right, so then I need my rule of the road. Or sometimes before I take an important deposition, you know what I mean? Because I feel like I've got to figure out what's my theme. And my theme is always developing and changing.
Yes.
I don't understand people who say, before you file the complaint, know your jury instructions and know your theme. I don't know that. I haven't met anyone yet. Like, how am I supposed to figure it out until I see the evidence?
Yeah,
but everybody's different. And I think you have to figure out what works for you and just live in that space, and pull information from people. It's
interesting because I was lucky enough that within, 8 years of my career starting, I got into nursing home neglect. So for the last 25 years, all I handled were nursing home cases. So it was kind of easier for me. I say this to all my med-mal friends. It's easier for me because, the theme is kind of the same in every case. I don't have to learn anything new. This case is a fall fracture case. This case is a pressure injury case, but they're all nursing home cases. So they all fall under the umbrella of the state and federal regulations. Whereas if you're a plaintiff lawyer like you are, you go from learning everything there is to know about orthopedic to, oh my God, the next one is a baby case.
Costco's policies and procedures, Albertson's cleaning policy, the Southern Nevada Health District, all about allergies. Yeah. No, I mean, it's amazing. It's a variety of knowledge.
And it's got to be hard because by the time you're at trial, let's face it, you better be an expert in that.
Yeah.
Right. I mean, you need to be able to speak with the confidence and in cross-examination when something you're not prepared for comes up. Well, you've read, the policies by heart, so you can throw it right back at that expert if you have to. How do you do that?
Yeah. I mean, that's the thing is like, if I can't say it in plain English, then I don't understand it. And so what I like to do is talk about it to other people and explain like, hey, I've got this case. This is what's going on in it to see if they understand it. Because if the jury is confused, they go defense. So you can never let the jury get confused. And so sometimes when people on the stand say something, if I'm going up against an expert, I don't understand what they said. If I don't understand it, jury didn't either. So what I do is I work with the way I understand it, which is usually in plain English, to make sure that they can understand it. But I'm lucky because my husband's a doctor and all of his family are doctors. So I get to ask them a bunch of questions. And I've befriended like accountants and people at the health district. And I can reach out and kind of ask them stuff that I don't understand. But I'm very lucky that when I go through something, I can pick out things that I just want to focus on. And while I stay focused on, like, let's just say a big old manual, I'm not going to go through and do all that. I generally keep it very basic. I rarely enter evidence. There's just no need to unless it's pictures or audio. I don't put the medical records in. I just do a summary of the medical bills and just submit the one page because the jury's not going to go back and look at that. And generally medical records hurt me.
I think there's no question. I mean, when you do that, do you have to have a nurse expert testifying? I've reviewed the records and the summary is?
Yes. And so I always have someone who does a records review or a billing review.
Got it.
So I can just submit if there's an economist, I'll just do a summary of his opinion on lost wages and, household services and stuff like that. And just have him confirm the summary and put the one page in.
So what you're telling, as you're empowering all these lawyers listening, hopefully they're listening, you're telling them keep it simple, stupid, right? That was told to me, I think before my first trial, and be as simple and not complicated as you can.
Exactly. And use your body and your voice. I think that's a major problem is people, especially females, do not understand the power in your voice. And there's a lot, and I think it might be a millennial thing, like, okay. And it really takes away from your impact to the judge and to the jury. And so like this case I had was about epinephrine, right? And I'm like, I don't really know much about epinephrine. Of course, I learned a lot about epinephrine.
Right.
But I just kept doing during the trial an EpiPen, intramuscular, IV. So the jury could understand what they didn't have in the bag. And I kept doing it the whole time. Like, it's the most basic thing. I was pointing at a vein. But the jury had no confusion as to what I was talking about when I was talking about IV, 1 in 10,000 part epinephrine.
Right.
You know what I mean? And so using yourself, because people are very visual, then you're not just standing there talking. And people are, gosh, Christian, you move a lot. I do. Because how the heck am I supposed to make my point just using my voice? I usually combine it with body movement and it keeps them interested.
Well, I love that. And I learned that actually from the Trial Lawyers College. I don't know if you remember Karl Bettinger, who was a nursing home lawyer. He wrote 12 Heroes.
I read that book. Yeah.
So Karl was also a doctor. And after his second $54 million verdict, and he recovered on both, he retired. Shock of all shocks. But Karl had a rape case in a nursing home, or it may have been an assisted living facility. And he pretty much in his opening statement made the jury look at the center of the courtroom as the bed and what happened. And he was really into the psychodrama. I mean, really. And he would walk around that bed every time, and the defense attorneys would go right onto the bed, and he would say that he could see the jurors look like, oh my God, you're stepping on the bed.
Yeah.
And Karl was simply just magnificent at doing what you said. So, I was talking to him. I was doing what you do. I asked people, right? I said, Karl, you're this brilliant psychodrama person. I'm this obnoxious Jewish kid from Jersey and Philly. You got to help me. How am I going to do this? He said, what's the core of your case that you're about to try? I said, they left her in the wheelchair. And that's how she got a pressure wound, which became infected and ultimately caused her death. He said, every time you talk about her in the wheelchair, squat as if you're sitting in a wheelchair. It worked.
Yep.
It worked. Everybody understood it. And I was sore as could be every night, don't get me wrong, but it actually worked. And I took it to the next level that in the nursing home cases, the regulations are everything, right? They are the end all be all, a lot like the trucking cases. And they're always in the same book. So I bought 5 books for trial that I would always bring and have it all over the courtroom. So that anytime anyone ever mentioned a regulation, I made sure I had the book in my hand. So by the time we got to the defense case, the jury was looking at us saying, that book that you keep holding is the most important thing there is in the world. And it really worked. I mean, I just anchored the book that way. And it's things like that. If you don't call and ask other people what they think, you may not think about it.
No.
I'd like to say...
I think that's the thing is and you know how many attorneys would be like, I'm not squatting in the courtroom.
Yes.
Oh, yes, you are if you're going to win that case. And that's the thing. It's not and I think that's another message that doesn't get said enough is these trials have nothing to do with us. We are just the tool to get it done. Mm-hmm. And instead, and when you put it in that fashion in your head, you stop being so concerned about how you look, concerned about how you sound, concerned that you're doing something that's ridiculous. If it's working to get you the verdict that you need for your plaintiff, then that's all that matters. And that really that's why so when I went to TLC in 2013, I was very buttoned up. I didn't want to do psychodrama. I'm not into that stuff, right? I was the last one to go. And it's amazing how being completely broken down in front of people really gives you the freedom to have the ability to say, okay, so I've really hit, I guess, bottom. And now I'm okay with trying all these things in front of my little safe space that I would never have done before. And I do think that method is very important because I like to hire young attorneys. I like to hire generally my law clerks. In fact, I don't know if she's listening, but I'll be making my law clerk an offer this afternoon. She just passed the bar.
Nice.
But I like to work with them in law school. And then I want to form trial lawyers. I want people who are excited about our profession. I want people who understand the power that we have. I want them to take a deposition with a purpose. I want them to write discovery with a reason behind it, not just because they're checking a box. And so it's hard to work with people who haven't gone through that experience. And I know they look at me and think, God, she's a little weird, but that's okay. I don't mind it because the weirder I appear to them, maybe the more relaxed they'll be to try something new and creative. Because when you have missed cases where you have, cases where it's not sexy, right? It's not, right. You have to be creative.
Oh,
you
absolutely.
have to find something that makes it interesting and the jury is going to care. And that takes creativity.
And that was so interesting. What you said is we're all so worried about what other people think, right? I don't want to look stupid. Stupid to who? Because if you do something at trial and it connects you with the jury and the jury turns around and gives a lot of benefits to your plaintiff, who do you look stupid to?
I think that's it. And I think there's so much judgment. I'll watch people and be like, other plaintiffs' counsel will be like, oh, that wasn't a great opening statement. I'm like, why aren't you applauding that attorney for standing up and doing an opening statement? You aren't, right? You're just sitting there judging them. And so I think that luckily in Nevada, we have a great amount of support in our plaintiff's bar, that anyone who goes at any time, we are there. But on the larger scale, because we're competitive in nature, I think that we become competitive with ourselves and we should not. It should be, if we want to say something bad, there's plenty of defense counsel out there. I feel bad for him, but I can say some stuff about him.
Yeah, no kidding. And I loved what you said. I want to talk to you a little bit about it because this is a pet peeve of mine. Discovery that people send for the sake of sending discovery. I don't get it. I don't understand it. And I can tell you for 20 years, at least, and to this day, and I haven't even practiced for 2 years, to this day, I get at least 3 emails a week. Do you have form interrogatories in this kind of case? And I'm like, well, what do you want to know in the case? This is my answer. And they get so pissed at me. Like, I just need to know what you ask. I said, well, it depends.
Right. It's, that's the thing is that, and people take depositions to discover the information. No. You have a point. And it's so cool when you have a point, because then you get really excited, like the closer you get to your point in the deposition, and it sends a message to the other side. I'm on a mission here, and I'm checking off certain boxes to get to my end goal, and it makes them nervous. And
I've always said, and I give credit to everything I've stolen, which is about 80% of my thoughts. I borrow. I don't steal. I borrow from other lawyers. Steve Levine from Levine Perconte in Chicago, great lawyer, great firm, always says, I'm not taking a deposition to find out the facts.
Right.
I'm taking a deposition to confirm things and to get rid of defenses. That's why I take a deposition. Yeah. I don't need to take 20 depositions to learn what 20 people think. I can read it in the records.
Yeah. I think that, and so stealing stuff or borrowing it, whatever, I think is amazing. I don't even know who sent out this email. It was on one of the listservs, and the guy had a trial, and it was a pedestrian versus car, right? And the pedestrian was doing something bad, like jaywalking. But his dire was, who here has seen pedestrians on the roadway? Raise your hand. Who here has hit them? Keep your hand up. And I'm like, that is brilliant. And so good. It's so good, right? And I'm like, oh my gosh, that's amazing. So I was taking the deposition of this door expert on one of those sliding doors, like the barn doors. And his opinion was there was nothing wrong with the door. And so I asked him, have you ever used these barn doors before? Right? And he's like, yeah. And I'm like, and how many have fallen off on you? No,
yeah.
But there's nothing wrong with this door. Gotcha. Right? Of all the doors, it's like you take it and you use it in your own way, because then he looks ridiculous, right? So there's nothing wrong with the door, but it just happens to fall off on her. Right. But none of your doors did. So there's so many creative ways to like steal and manipulate. But I thought that was just a brilliant, simple, amazing example in Vadire.
I mean, as great as I worked with Don Keenan down in Seaside, where, with the nursing home group and things like that. I would tell everybody, I don't think I've said this yet on the podcast, go get the Old Mo Levine tapes from Trial Guide.
Oh, don't. Right? I listened to Mo Levine on summation on my way to trial, every closing argument.
That's all you need to do is go get the Mo Levine tapes. If you don't want to read all these books, and I think these books are brilliant, I love every one of them, just go get the Mo Levine tapes, because before there was Reptile, there was Mo Levine, who was doing the same thing.
I use it when he says, you sit in judgment.
Yeah.
He says, I say it in every trial, you will sit in judgment in this trial, and they can feel it. Because the way he said it, I say it in the way he does, because I got goosebumps when he said it.
There's no question.
He's amazing.
So, I mean, if anybody's listening to this and they learn nothing else with Christian and I going back and forth on all the cool things that she does, just go get the Mo Levine tapes and listen to them, because they are phenomenal.
Oh, my favorite quote from him is, if you want $1 million verdict, give me $1 million case. It's so true. Everyone's like, oh, I want these $1 million verdicts. You have to have the $1 million case. You can't take something that isn't $1 million case, not get $1 million, get something lower, and then be upset about it. Right. It's not $1 million case. And he talks about that one case he had with a little Black girl in the South. Yeah. And he was able to get, I think it was like $25,000 for her. And that was his true win. And because they didn't value her. Right. And I was just that really sticks with me. And he was just amazing. I couldn't agree with you more on Mo Levine.
And by the way, everybody I talk to who tries cases like you do, love Mo Levine.
Yeah.
To a person. And of course, on the East Coast, which we're both from, it means a god in New York. I mean, he's Mo Levine.
Yeah.
So it's interesting, but so on the deposition, when you're taking the depositions, tell me about your style a little bit. Are you arguing to get your point, or are you simply listening and using the words that the witness gives you?
Yeah, so I don't ever argue. I ask some questions. In fact, I'm a really polite individual. And so I don't like confrontation. And if I'm going to ask a question that's even slightly offensive, which occasionally I do because I dirt dig on these experts, like I find out about their bankruptcies, their malpractices, their credit card statements that are unpaid. I sweat because I'm not looking to like degrade and diminish someone, but it really does depend on the type of expert and what I'm going for, because most of the time their reports are the same, right? We see the same ones over and over again. And so I'm looking for fun little interesting facts from them, where the other day I was taking a deposition of a guy. I find out that, he uses free space here in Nevada. Like some guy just allows him to use this free space. So he flies in from California and only does defense work, gets free space, gets all this money, and all he's trying to do is come into our state and defeat our citizens' claims. And so, I'm looking for facts that I can use to expose who these people really are, because they're not, most of them are doctors, right? If I'm doing Dr. Depo,
right.
I like to make it clear. So where did you learn this IME, independent medical exam? Do they teach that in medical school? Oh, you have a side gig. Okay. And your wife runs it. Oh, out of your basement. Okay. Right. Let's take a look at who these people really are, because they come in cloaked in so much credibility with their Yale and Harvard and whatever else they might have gone to, that sometimes I'm just looking to expose the reality of what they're doing. And then sometimes I've read through all of their articles and I'm literally just testing on, because I use their articles every time in cross-exam, because their articles never support their opinions. And that's just a fact. Or they're using a lower back, asymptomatic article to talk about a prior symptomatic neck injury. And so I'm testing them to see how they'll be when I cross-examine them. Because if they're confrontational, I'll know I need to do a different angle. And so most of the time I'm trying to meet them, trying to get a few good quotes, trying to get a few fun facts, and test how they're going to be at trial. And sometimes I can knock it out of the park with other stuff if I've got some good stuff, but most of the time that's what I'm doing, because I don't get into the ring with them all that much unless I really can.
So you have a plan. You're not just going in there asking them questions. You have a plan and you're utilizing that plan, right?
Yeah, absolutely. And so what I do is with my law clerks or my young associates, I'll have them prep me for the depo. And then I will tell them all the things they missed in the prep of me. And I'll say, you should have gotten this, you should ask this should be this way. And then they'll listen in on the deposition.
Got it.
And that's how I teach them. And that's why I'm trying to teach people, you don't just sit around and read the report and take the depo. It doesn't work like that. It's the most futile thing you could do. And I also do think it helps a lot for me that I'm not just anymore a one-woman show. I would encourage attorneys, use law students. Use them, tell them, hey, prep me for this. Then they're in there struggling, trying to figure it out. And then you're able to kind of have something to work with. And then you've got this flow of energy between two people. You're not just sitting by yourself at your desk, biting your nails, trying to figure out what to do. And so I think that working as much as you can with another individual, bouncing ideas off people, talking to your staff about stuff, helps you be more creative, because I can't tell you how many times I've talked to someone and be like, oh my gosh, I never thought of that. And it's like,
I think that that synergy is so important. When I was a true solo, we, 4 of us got together and got a big office suite so that we were all solos, but we would share the conference room, we'd share some secretaries, but more importantly, we'd share each other. We'd be able to sit down and say, what do you think of this? And I, on more than one occasion, had people say to me, have you lost your mind? There's no one will care about what you just said. And damn if they weren't right. And in fact, if you're simply going to go, I'm going to come out and say, if you're simply going to take an expert's report and ask them about each paragraph why are you taking their deposition?
There was a defense counsel taking a depo of my expert the other day, and this was literally it. Now, the first sentence says this, and he'd read it and then be like, did I read that right? And the doctor would say yes, and then he would move on. So are we testing your reading skills? Like, I'm very confused. What's the point? He was just trying to fill up the hour.
And I also have, and I trained way too many people over the years. I've also said to them, if you're taking a deposition of a nurse, right, because it's nursing home and you're asking them to read what they wrote into the record, what are we really doing? I mean, do we just have money, or we just want to hemorrhage money to the court reporting service? I mean, what's the goal there? Yeah, just don't do it. I'm a big believer of inoculate defenses and depositions, and just get sound bites for trial that I can use against the expert.
And these days, the insurance companies are not preparing the defendants. So I love to do basic things like, and so what's the name of the person who's suing you? I don't know. Okay.
Interesting.
It's amazing. And I never correct people in depositions. I always think it's weird when someone, like a defense counsel, will say, and on what date did this happen, right? And the plaintiff says, I don't remember. Well, this is this horribly monumental day, right? Where you were devastating the injury. You don't know the date? Gosh, you're going to look bad at trial. But instead they say, well, if I told you it was October 10th of 2017, would that sound right? And then the plaintiff says yes. And I think, why are you missing that amazing opportunity? Because I asked the defendant, they don't know. What street we on? They don't know. They don't know. They don't know. They don't. I'm not telling them. No. And it's beautiful because they're going to act like, look, this is really important. I got sued. I shouldn't be held accountable. Really? Because you don't even remember anything about it, much less the day it happened or the person you injured. And so like, it's amazing to watch people like destroy phenomenal opportunities that just pop up.
Well, that is fascinating. So you're looking at everything you do in a deposition has a purpose, has a reason.
Yes. And I figure if they know the name of the person and they know the date, they're going to make a good witness based on very basic information. That I'll be like, all right, so this defendant is engaged, right? They know some stuff. And I need to be able to evaluate how to handle them because most of the time, as you know, we're not going after the individual defendant, right?
Right.
You got a car crash case and the guy didn't hit his brake. Like no one's going to hate that person, right?
Right.
You've got to figure out how to make the defense counsel look bad. That's going to be the angle, right? You're going to show how they've used the system to try to get away from this responsibility. And so going through the answer with the defendant and the defendant who presents well and knows the basic facts, but does not understand all those affirmative defenses, why basic stuff was denied, then they're going to have to put it on their counsel. And they will put it on their counsel, and that becomes the evidence.
We often, and I forget who told this to me, but I took it from someone else, and it's brilliant, especially when you're dealing with a trucking company, a hospital, a case like that, and the one lawyer represents everybody, whether they know it or like it. It doesn't matter. I always try to create some sort of separation between the lawyer and the witness.
Yes.
And it's normally asking a simple question. The lawyer jumps up and down, objects, and then you say, well, did you hear what your lawyer just said? Are you following that advice? Yeah. Okay. And you could start separating them, saying, well, this guy's not going to put me through another 2 hours of deposition because the big mouth lawyer objected to something that's stupid and said something that's not true. And that really helps if you can do that separation, because by the end of the deposition, they're thrilled to throw that lawyer right under the bus.
Yeah. What's interesting is I think that people like car crash cases, and I really don't. I like trucking cases. I like anything where I can get a corporation on the other side.
Right.
That's why I love slip and falls and I love trip and falls. Because the jury gets really interested in the policies and procedures and the cleaning schedules and all these other things. And they're not really looking at the poor porter who is supposed to be going through there and waping up the liquid, who obviously never did. They're looking at how this company functions because they're making money off the public. And that's why I think things like car crash cases where you've just got a defendant can be very, very difficult cases to get the jury upset. because
Right.
you need to get their blood flowing and get them saying, I want to right this wrong. And it's really difficult with just that one individual sitting up there who, rolled through the whatever.
Well, at the end of the day, I mean, how is a juror not going to look at the defendant driver and say, that could be me in 2 hours?
Yep.
Right. I mean, there's just no way you're going to get, unless that driver is really a nasty person or a drunk or something.
Right.
They're always going to feel for that person. It's just not, it's not, as you said earlier, it's not sexy.
No. That's where you got to get creative. You got to find a way. And that's another thing in the deposition when you're facing it. Sometimes I do push hard just to see if I can push them over the edge, because nobody likes a nasty person on the stand. And so if I can get that from them, I know I've got that going for me.
Before we started the videotape depositions, I always pushed hard at depositions because, it doesn't come across if you're reading it that I'm pushing that hard, but I'm really testing them, that witness, to find out what I can do at trial or how I can use it at trial. Once we started to videotape everything, it was used against me on more than one occasion, pushing play
you
and hearing.
Be careful.
Oh, it's horrible. There's nothing worse than sitting at trial and hearing yourself be an asshole to a witness, and then everything you've just done for the last 4 days to show you're off code as a lawyer is done.
Mm-hmm.
You now have no credibility, and it's just horrible. So just a little tidbit for those of us who tend to be aggressive at depositions. Don't videotape it if you're going to be aggressive.
No. And the jury does judge you. They really do. So at the trial I just had, there was this one medic, and instead of treating my client for what she had, which was an allergic reaction, she kept assessing the patient. I was assessing the patient. Well, the patient already told you what was wrong with her.
Right.
So why are you assessing her? And I kept going at her and at her and at her because this girl is dying while she's being assessed, and she's already told you what's wrong with her. And so when the verdict came in, you can talk to the jurors after. And the jurors were like, because they had no criticisms of defense counsel, except for that they seemed like those evil insurance guys that you see on TV, which I thought was pretty accurate. But they had a ton of criticism for me, because I always say, I'm always looking to improve. What did I do that was annoying to you? And they kept saying, you can't just, if you don't like the answer to a question, you can't just keep asking it. Well, I was continuing to ask it because I wanted them to see. And they were like, it became a meme. Assessing the patient. And I was thinking, like, yes, it worked, right? But they found that to be annoying in what I was doing, but it doesn't matter to me, right?
Right.
I have to listen to it, take it with a grain of salt, because I got my point across. I just ticked them off a little bit while I did it, but I needed to do it that way.
Right.
So it's always funny you never know how it's going to hit people. That's why you have to be so careful, unless you've really got something you need. And then you have to go for it, even if it might annoy them.
Somebody once told me, and I have no idea who it is, and I agree with it 1,000%. I hear all these lawyers saying, well, I'm going to kill that person at trial. I'm like, okay. And if you really go in for, quote unquote, the kill, you better get it. Because if you don't get it, you've lost.
Yeah.
And it's a scary time, because I've been on both ends of that. I've gone in for the kill and I've destroyed it. And I've gone in for the kill and the jury laughed, and you step back, you sit down, and you just like, all right, I'm going to go to the bathroom now. I'll see you guys later.
Yeah.
It's because I'm done. Nobody needs to hear from me.
I think the importance is the consistency, because you want the jury to trust you. And
the other thing is, I really do believe, I have a client of mine who's an Oregonian lawyer trying a case as we speak. He just emailed me in an arbitration where I said, look, we have all this great information. And if we give all this great information to the arbitrator, there is not a chance we're going to win. Let's strip it down. Let's only pick our 3 best documents, our main points that we have to do, and that's our cross-examination of every expert witness.
Yeah.
Is that something you do?
100%. Frankly, I probably do it for self-preservation. I don't have that much time. And, I like to, I'm trying to learn to share more. But I like to do all my stuff in trial. I got to do whatever. I got to do opening. I got to do my plaintiffs. I got to cross, you know what I mean? Like, I have control issues.
Yeah, don't we all?
I can. I really have to, for self-preservation, keep it as simple as possible, because I tend to get disorganized. if I have a bunch of papers, I can never find the paper I want. I'm sure it's directly under my face, but I can't. And I'm on a mission. And so my mind keeps on that one level. Where there's other attorneys, I watch them, they're just amazing, right? Keeping themselves organized and all that other stuff. And so I really think it depends on how your brain works as to what you should be doing when you're at trial, but you have to remember that the jury can only retain so much information.
Sure. That's exactly
and an
right.
arbitrator, frankly, probably didn't care that much, right? Let's be honest. And so you want to make sure that the points stay in the front of his or her head so they don't have to think too hard.
I like going back to what you just said a few minutes ago, the meme. I want the meme. That's what I want. So, and if it means that I'm going to be cross-examining an expert, ignoring most of what he or she said and just go right through my points again, I'm happy doing that.
Yeah. Oh, and I mean, I think the other thing too is like, you have to be able to pivot. I can't tell you, like, I was crossing this expert and all of a sudden he was talking about this one study about epinephrine. And he's like, well, I said, there aren't any human studies, right? And he's like, well, no, it was a rat study. And he's like, yeah, but did the rats die? And I was like, did the rats die? I was like, what? You know what I mean? But instead of like letting it go, because I didn't know what he was talking about, I said, what are you saying? Are you saying that the rats that get the IV epinephrine die? Did they survive the rat hospital? And I was like, there's a rat hospital?
Wow.
It got to be hilarious. The jury was laughing. It's just, and there was another weird expert, and he was trying to change his testimony. And he was trying to say that he was using a special allergist language when I deposed him. And since he wasn't using a special allergist language on the stand, that's why his testimony was different. And so he started using like Latin phrases. And he said something, and he's like, that's my opinion in toto. And I think because we're wearing masks, right? I'm like, I think he said in total. But then I just said, I don't know if he did. I said, in total? And he's like, in toto. And I'm like, in toto? Right? And we're going back and forth. And I looked at him like we're not in Kansas anymore. Yeah. Sherry busted up laughing. Like, there's so many ways you can cross-examine. And they literally, like, after the rat hospital, they just kind of like checked that guy off.
Yeah,
and
exactly right.
Using like this weird language. They kind of checked that guy off. And so it is funny how you can discredit what you're not even really going with what their original opinions were. They're just kind of, and you have to remember, these experts are nervous. They're nervous, not all of them, but you'll find some really nervous experts, and you can do a lot with that.
And I think, I could be wrong about this, but I and I'll preface it with, I'm in this group of a bunch of business lawyers, but it's about the business of law. And they keep saying that their offers that they're getting aren't big enough. And they follow Nick Rowley's, running with the bulls, and they do all this, and they have a demand letter service, but still they can't get the right offers. What do we recommend? And I'm one of the only true trial lawyers in this group. And of course, my first thing I said, well, how many cases have you tried? And it's like, well, none. I'm like, oh no, there's your first thing. You got to go try 5 cases, because they're not going to take you seriously until and unless they know you're about to finance a trial and actually go through with it.
Yeah,
and
it makes a huge difference. And
I think sometimes those experts will get nervous when coming up against someone like you, who everyone knows you're ready to try the case, any case, because they're told by the defense lawyers, now look, she tries a lot of cases, she got a big verdicts, this and that. Now all of a sudden they're starting to sweat a little.
Yeah.
And that's one of the things we always loved in my old firm, because I never did the defense expert ever, deposition ever.
Oh, interesting.
Someone else always did it.
Huh.
I didn't, unless I knew them, I did not want them to know my mannerisms, the way I ask a question, I don't ask open-ended questions necessarily. I ask questions that can't be answered on cross-examination, right? It doesn't have to be a closed question. It's just a question that it doesn't matter what you say, I win.
You're telling the story.
Yeah, and I don't want them to know I do that until we're in front of the jury. And so I always made a point of that. And I know the defense lawyers were always telling them, look, this is the way he is. Let me show you. We have transcripts from him. And I knew they would be getting a little worried. And I always liked that. But that may be something that only comes if you're trying a lot of cases.
Well, that's the reality is they do research on you,
Nope,
and they'll know. And that makes a huge difference. The beauty of it, though, is because it's so dynamic. When there's an attorney who has a case, they can't get the value on it, and then they bring in a trial attorney.
Right.
And all of a sudden, they'd like to go to mediation.
It happens every single time I got brought into a case. So it was, well, how about if we mediate it? I'm like, well, how about if you just make an offer? We can do this the old way where you call me, we talk about it, we do some numbers. But so again, this is Saul Gruber from The Jury Thinks What. We're with Christian Morris, superstar lawyer out of Las Vegas. I'd be remiss if I didn't go back to your verdict, because it was the talk of the town and still is the talk of the town. And everything we just talked about, I'm presuming, were things that led you up to getting that verdict. Why don't you tell our listeners a little bit about that case?
Like every large verdict case, it's a tragedy that occurred. And a beautiful 27-year-old model who had a peanut allergy is now suffering from severe anoxic brain injury. She cannot swallow. She cannot speak. She's a quadriplegic. She lives in her parents' dining room in Michigan, and her mom is her full-time caregiver, and she requires full-time care because she cannot be left alone. And it was really, it was interesting because it was a case where I was really lucky to have a great strategy in that I sued Medic West, which was the medic company that had two medics there who, in our allegations, delayed care for her allergic reaction. And when you're having an allergic reaction that's going into anaphylaxis, time is of the essence. You need to move. And they didn't have what's called IV epinephrine in their bags because Medic West, which was required, decided they wanted to save $2.42 per bag because the medics just didn't use it a lot. Epinephrine expires and they'd have to throw it out. So they just didn't equip their medics with the IV epinephrine that Chantel desperately needed because she had basically in their presence gone into full anaphylaxis, lost consciousness, stopped breathing. And so I had sued them and they were my main defendant, but I'd also sued other parties in the case and where the convention occurred and the people. So what happened is she bit into a pretzel and didn't know it had peanut butter in it because it wasn't labeled.
Got it. And
the minute she found out it had peanut butter in it, she ran to the bathroom. She gave herself her EpiPen. She called her dad. She sent her friend to get Benadryl, and she went to the medic station. And so I was able to resolve with all of the other parties. And I didn't really care about them because Medic West was my real defendant in the case. But I was able to have this cushion, right? So if I lost, I didn't really lose, right? I've already got some stuff going on. So going to trial, it was one case I could fully invest in. I could do endless focus groups. I could do expensive jury research. I could get all the big number data. I could get expensive animations. I could have a tech guy who does all of my PowerPoints and stuff like that. So I really was able to, where you're, for the first time, really hugely invest in something because it was one that was worth doing. But it was also, a case that had been going on. This happened in 2013. This was an old case.
Wow. And you just tried it this year?
Yes.
Wow.
So this was one where they kept pushing it off. And I was ready to try this case. I had my little girl in January of 2020. I was standing in the courtroom in December saying, I can put this case on. I can do this. And the defense wasn't ready. I'm like, look, I could pop any moment and I'm ready to fight. But they pushed it and they pushed it. And then the judge was awesome. She's like, you are going. But it's like, gosh, we're in a pandemic. I'm suing a first responder. It's a 3-week trial. We all have to wear masks. We're in this big convention center. We're like super far apart from each other. How am I going to connect? And so, I had concerns, obviously, in that area. And then, there was a lot of self-responsibility concerns. She knew she had a severe food allergy. She put something into her mouth that she did not know the ingredients of.
Right.
And so that was something that I knew we had to hit on as well. But I was really lucky because the defense, I don't believe, thought the case was actually going to go. So they were not prepared. And that's just a fact.
Wow.
And I'm so grateful. It made my job so much easier. But it really was one where, I was rusty. I hadn't tried a case in a year and maybe like 3 or 4 months. I was, I did 5 focus groups back to back on voir dire and my opening, voir dire and my opening, voir dire and my opening, to get used to doing it, to practice some new stuff that I wanted to try, to make sure that opening was on point, because I fully believe you win your case in voir dire and opening, and then you just don't fuck it up. That's it. You tell them and you give them everything you promised them, and then you close it out. But it's a matter of that had to be down pat for me. And I was working with all of the excuses and defenses, finding ways to work it into my voir dire.
Right.
And so I was practicing, because you got to practice, because sometimes you use an example and people are like, what? And you don't want the jury to do that, because they form their opinion of you in voir dire. And so you have to maintain your credibility. And if you don't maintain your credibility in voir dire, you're not going to get it back.
It's funny that you say that. I always had this question I would use in wrongful death cases, which were most of my cases in voir dire, is, some people think we're all going to pass away no matter what. So it really doesn't matter how you die. And which way how do you feel? Does it matter how you die? And I've used that probably in 15 trials. In 13 trials, it's been magnificent. It's been perfect. You get people who say absolutely, and then you can turn around and use what they say in your closing argument, right? Remember when we spoke here at voir dire, we talked about this. And then there's that couple trials where I had George just look at me like I had 3 heads. Well, I don't even know what you mean. What kind of question is that? I'm like, I don't know. I'm never mind. I don't know what to say to you.
Yeah, I mean, that happens. You try to do these things and people are like, what? And you're like, ooh. Yeah, but it was really fun to be able to work on such a dynamic case, because when you have a dynamic case, you don't have to worry about all of the things that you have to be worried about if it's not such a dynamic case. And so, I stood up and I was able to tell them just a little bit about the case. And I told them that Chantel would not be with us because she can only travel by air ambulance. And so she would not be in the courtroom. And, her family would mostly be remote because they're caring for her and they can't be exposed. And then for the first time ever in my whole life, I said, does anyone here feel like that no matter what evidence I give them, no matter how much evidence I have, that they would never be able to put down a verdict for $100 million onto a verdict form? Is there something inside you? And usually, if I use a big number, I get this like, no one had a problem. And I knew it was because they knew that this was a big deal.
Yeah.
And I think that that's something that we have to struggle with in a lot of cases. And I had so many concerns, but I realized numbers were not going to be a concern.
Interesting. And it really, depending on what kind of case it is, you've got to get something like that in voir dire, because I can remember a case where we had a pressure wound case and the pictures were just, I don't know if you've ever seen a picture of a real bed sore, but they're just ugly. Nobody's ready for that.
No.
And the defense is the 3rd or 4th trial I've had with this defense firm, and they thought they were ready for me. They made a motion that we show the pictures to the jury in voir dire. And of course, my instinct immediately is, well, if they're filing a motion for it, we're against it. And the person I try cases with, Tori said to me, well, think about this. Wait a minute. Why does that hurt us?
I think it's amazing.
Why would that be bad?
Yeah.
Okay. And we did it. And it was great because it almost took what I'm always worried about. This is an important case. This is a big case. And it made it for me.
Yeah.
Without me having to do it. So, I mean, if you can think of anything like that to do in your cases, I really think you need to.
Were they trying to inoculate the jury? What were they trying to do?
I think they were trying to have the jury just be so desensitized to the picture,
Gotcha.
or find out really who would be so disgusted by it before trial they would get rid of them, and we'd ask that question. And because they did that, we ended up never showing the picture at trial.
Right.
We had it in an envelope and everybody knew what it was. There were like 2 or 3 pictures. And all I had to do was pick that envelope up and cross when someone was saying it wasn't that bad. And you saw the jury wince, but I never showed it again at trial because I didn't have to. And I gave it to them. We moved it in evidence. I said, it's in this envelope if you want to look at it again.
Yeah. It's interesting. In mine, I only showed a few pictures of Chantel, who was absolutely beautiful. Right. I can't even tell you. I mean, but I had done a very long day in the life video, and it was heart-wrenching. I would cry every time I watched it, and I watched it a lot, right? So I used the day in the life video to do some jury research, right? Some watch the video, some not watch the video, and see where the numbers were. The day in the life video drove the numbers down. Interesting. Because people thought, wow, she's in such a bad condition. This money isn't going to help her. So I was like, wow, I never would have thought that. And so I used the day in the life video, but I only used the first part where this was her as a girl and her aunt's talking about her, and her mom talking about her. And then just a snippet of what her life was like currently, and her using the IV's computer to to talk. She can communicate by looking at words. But it was perfect. And then at trial, I just had her shortly on video with her mom sitting beside her, showing us the exercises that she does with her. And then turned the camera to just let the mom testify. But it's interesting, the things that you just wouldn't know unless you asked.
Well, I have a question for you. When you did that, did you do that to a live focus group or online?
So I use John Campbell, empirical jury. He does everything.
Who doesn't use John? I use John Campbell to help me with.
Okay, he's in Madrid right now. I want to be John Campbell. Yeah. He's like between Madrid and Colorado. I'm like between my upstairs and downstairs. He's like, lucky me. But, you basically, all I did was I wrote a closing opening for both sides. And I sent him some key information on depositions, the protocol that wasn't followed, and the day in the life video. And he did all the work.
So he did all the survey. He did mainly surveys. Yeah,
he just presented the information to these live focus groups. And then, was able to tell me, I want females. This is where people find issues with self-responsibility. Like things that I need, like you want someone who watches American Idol or something. I'm like, why would it, what does that tell me? You know what I mean? I don't ask questions like that in Woodire. That's just, who here watches American Idol or something.
Well, it's interesting because we've worked with John's group because we do a lot of focus groups for our clients. Mm-hmm. And then we've worked with them to augment the focus groups we're running and to try to do some surveys and things like that. And really to drill down a little bit more on what type of jury you really want. And it's really good stuff when you put it together.
I got to tell you, for the only time in my whole career, when this woman, a lady had to leave because she saw no point in money for pain and suffering. So she got out and this woman took her seat. And when she stood up, I was like, that's my forewoman. And I knew I had to kick another guy who had a very strong personality. And during trial, she asked intelligent questions to the economist. Did you use the nurse care planner's high or low number? And she asked a question that wasn't allowed to be asked because the defense objected. But I made sure to answer it in closing to her directly. And, I said I was worried when the verdict came in so quickly. Well, I walked by the jury room, which was the convention room that we've been in. And the blue folder was in front of her, which is the verdict form. And I walked back to Jack. I was still nervous, but I said, we have a plaintiff's verdict. She's got the folder. Wow. She's my lady. And she was my lady. She got it done.
And that's interesting what you just said. And that's something that I've heard so many jurors afraid of, trial lawyers letting the jury ask questions if you're in a jurisdiction that does that.
Oh my God, it's amazing. The insight you get.
It's crazy. Yeah. I always did. In New Jersey, we were allowed. And you get it's like mini focus groups in the middle of the trial. Yeah.
And the funny thing is even if I'm saying, no, I don't want that question to be asked, I'm nodding. So the juror thinks I want their question asked, and it's the other side's fault.
And invariably, if I could, I would ask that question to the very next witness. If it was on my case, that would be one of the first questions I would ask to the next witness.
Yeah.
And just look like you did. Look right at the juror who handed it in, or you could, yeah, it's great. It's brilliant. Don't be afraid of that.
Oh my God, so helpful.
Well, Christian, we've been at it for a while.
I know.
This is fun.
Yeah.
This is Saul Gruber from The Jury Thinks What. More importantly, we're with Christian Morris from Nettles Morris out in Las Vegas. We didn't get too much into your big verdict, but you know what? That's why you're doing Trial Lawyers University and all the seminars where they can really break it down. I wanted to find out a little bit more out of your head how you look at trials, and it was so great. Thank you so much. I really appreciate it.
Yeah, you're welcome. I'm glad that you allowed me to talk more about the organics of what we do as opposed to the finished product. I think that's really essential for people who say, hey, I want to be a trial lawyer. How do you get there? Is you don't just get there. You have to work from the ground up.
Right. Well, thank you again. And I appreciate it. If anybody's listening to this and they want to know how to get in touch with you, what's the best way to get you?
I mean, I'm quite accessible. You want to find me on Facebook? I'm under my name. No, I'm just kidding.
So they'll contact your office, and what we'll do is we'll put all your contact information, your office contact information, along with the podcast so they can get you. So again, thank you very much. I appreciate you joining us today.
Yeah, thanks. I appreciate it.
Thank you again to Christian Morris from Nettles Morris in Las Vegas, Nevada. This is Saul Gruber, the host of The Jury Thinks What, a podcast for trial lawyers. And the tips you got from Christian were nonstop and continuing, from her mindset of always being excited and not criticizing her client, to why she takes depositions, why she takes discovery, into the mindset of voir dire and trials was just astounding. Every minute of that interview had another tip and something else that we all should be following. I want to again thank Christian for her phenomenal tips. I hope to have her back on again because she has that much to give. Again, this is The Jury Thinks What, a podcast for trial lawyers. I am Saul Gruber from Gruber Trial Consulting. I want to thank everyone for listening and subscribing. And if you know anyone who you think would benefit from this, let them know. Send it to them and let them subscribe. And again, if you have any questions, we're here. Just give us a call. Thank you.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.